Good afternoon, and welcome to the inaugural Ignatian Migration Dialogue. I'm Bridget Cusick, VP for Marketing, Communication, and Outreach at Jesuit Refugee Service USA. Ignatian Migration Dialogue is our new webinar series featuring JRS USA leaders and guest experts discussing pressing challenges related to work with migrants and refugees. Today's focus will be litigation, and we'll say more about that in a minute. First, I want to let you know about what else you can expect to see here. For starters, please mark your calendars for Tuesday, October 28th, when we will hold our second Ignatian Migration Dialogue with Archbishop Thomas Wenski of Miami. Archbishop Wenski is a longtime defender of refugee and immigrant rights who was most recently in the news related to his advocacy for detainees at the South Florida detention facility, aka Alligator Alcatraz. In future weeks and months, we will be covering topics including federal policy changes, mass deportations, immigration detention practices, religious liberty, and birthright citizenship. And in each case, we will be in dialogue with an eminent thinker, legislator, scholar, advocate, or other important voice on the issue. Now I have the privilege of introducing you to Donald Kerwin, JRS USA's Vice President of Advocacy, Research, and Partnerships, who will moderate today's discussion. Before joining JRS, Don held leadership positions in the Catholic Legal Immigration Network, the Center for Migration Studies of New York, and the Migration Policy Institute. He has served as a senior fellow at Emory University's Center for the Study of Law and Religion, and as a senior researcher at Notre Dame's Keough School of Global Affairs. For the past 12 years, he has served as editor-in-chief of the Journal on Migration and Human Security, a peer-reviewed public policy journal featuring articles about creating conditions in which people can make free and safe decisions to migrate or stay in their home countries. With that, I'm going to hand over to Don, who will introduce today's panelist and set up the discussion. After about 25 minutes of conversation, we'll take Q&A for 15 to 20 minutes or until we run out of questions. So please use the Q&A button on your Zoom interface if you'd like to submit a question. Don, over to you.
Thanks very much, Bridget. And we're very honored and excited to have Sam Callahan with us today. Sam is a senior associate at the law firm of Arnold and Porter and co-counsel in the Global Health Council versus Trump case. That case challenges the administration's withholding of appropriated funds as part of a broader freeze or suspension of foreign humanitarian assistance. Sam is the former senior counsel of the White House Office of Management and Budget. He's a member of Arnold and Porter's appellate and Supreme Court practice groups. He has secured major wins in landmark cases involving the Administrative Procedure Act, constitutional and statutory interpretation, and government funding, all of which are very good training for the Global Health Council litigation. Sam clerked for Judge Paul Niemeyer of the U.S. Court of Appeals for the Fourth Circuit and Judge Christopher Cooper of the U.S. District Court for the District of Columbia. He graduated magna cum laude from Harvard Law School, where he was an executive editor of the Harvard Law Review. Sam, thanks so much for joining our very first Ignatian Migration Dialogue. We're thrilled to have you.
I'm thrilled to be here. Thanks so much for having me.
If it's okay with you, I thought I'd set the stage, for this conversation by describing the experience of our agency, Jesuit Refugee Service, that I think is related to kind of the litigation that you're leading at this point. At the beginning of a very long year, JRS, Jesuit Refugee Service, had 9 cooperative agreements with the U.S. State Department's Bureau of Population, Refugees, and Migration. So not USAID, but from the Department of State. And these programs were all very successful and life-giving and dignity-affirming programs. All involved the direct accompaniment of refugees, meaning people living with the refugees, which is kind of a signature quality of the Jesuit programs around the world. After the first Trump administration took office, JRS USA received notice that the programs would be reviewed and paused for at least 90 days in furtherance of the administration's January 20th executive order on foreign aid. There was a provision for waivers for life-saving services, and our agency went through a process of identifying which of the services we were providing were life-saving. Is the administration very narrowly defined that term, and it's a definition that we don't agree with at all, but nonetheless, we went through that long process. But the effort really turned out to be for naught because 7 of the 9 cooperative agreements were terminated without cause and without any explanation. So really, the way for all the talk of kind of fraud in these programs, this was like a fraudulent process itself for us to have to go through. We were offered a chance to then modify 2 of the programs, which we did, but only one of the modified cooperative agreements was actually accepted. So at present, only one of the 9 cooperative agreements are still in place. Within a couple of months, funding, as you know, nationally for nearly 90% of international humanitarian assistance had been wiped out, with immense human consequences and lost prospects for refugees in our case, and in lost lives in some cases. And that was our experience as well. So JRS USA in the meantime has worked very hard to preserve what it can, but it took a real hit, as in particularly the populations that were served by these programs, and really a totally unnecessary one because the funding had already been authorized and appropriated. So, I mean, I guess I'd start with just this simple question. Does that report, does that story sound familiar to you?
Yeah, and thanks, Don, for that story. And I'm sorry to hear the tale, and I appreciate that all you did under those programs, and all you're doing to try to preserve as much as you can going forward. The short answer is yes. That is a very familiar story. I mean, as you alluded to, there was an executive order on the first day of the new administration that halted foreign aid spending across the board. It was styled as a freeze, as you mentioned, for further review of these longstanding foreign assistance programs, humanitarian aid, pro-democracy work, all manner of USAID and State Department programs. And during that period, yes, there was a sort of narrow exception for certain programs. My understanding is that very few, fell within that exception, even fewer than you might expect based on its narrow text. And that at the end of that period, vast majority of existing grants, contracts, and cooperative agreements were terminated. So it's certainly, while it hurt each individual organization gravely in ways that you described, it's a seemingly universal problem, and what prompted the litigation that we can discuss in a moment.
Yeah, I mean, I guess my next question would be like, as an attorney, where do you start in trying to remedy an injustice of that magnitude?
It's a great question, and it's one that I think varies based on the nature of the injustice and how high profile it is. And something like this that comes in the form of an executive order, and I could just give as an illustration sort of how things unfolded here. I worked in the Office of Management and Budget in the prior administration, as you mentioned, and I found myself out of a job as a result of the election, as many of my fellow appointees did. And so, at the time this order came down, I was between jobs. I hadn't started here at Arnold Porter, but my sort of network of folks who are very interested in making sure that the government abides by the rules and protecting important government programs that we supported during the prior administration. We take notice of these types of executive orders. And so, immediately when you see something of this magnitude, it takes billions of dollars that Congress has said further these important humanitarian and other objectives, and just says across the board, no, we're not going to be spending this money anymore. We're going to conduct this freeze while we review it. I didn't have really any history with foreign assistance work, with the State Department, with USAID. But immediately, this caught my attention. And so I reached out to contacts who I thought might have some connections with people who would be affected by this, and started to try to evaluate how was this happening, how was this being implemented on the ground, and whether there might be basis for challenging it in litigation. So the short version is, with an action like this, attorneys do tend to take notice, but there are a lot of actions that the government takes that don't always have quite such banner headline effect.
Mm. Maybe it would be good just to give us a few minutes on the Global Health Council versus Trump case, which has run a very procedurally complex course and is a live case as we speak. But why don't you just go over some of the highlights?
Absolutely. And yes, I will say that in my, at this point, 8 or 9 years of litigation experience, this is probably the most procedurally complex case I've ever been involved in.
Mm.
And the reason for that is we brought this lawsuit in early February, shortly after the executive order that you mentioned came down. But we challenged two separate aspects of what the Trump administration has done with respect to foreign aid funding. So one tranche is about the cessation of all appropriated funding for future programs under the foreign aid appropriations that Congress has created. So our allegations on that side of the case are that the executive branch here is unlawfully impounding funds that Congress has appropriated. And, folks, you've probably seen in the news the mention of impoundments. There's a law called the Impoundment Control Act. But basically what an impoundment is taking a sum of money that Congress has said that the executive branch needs to spend, and the executive branch saying, no, we're not going to spend this anymore. And there's a history, we could spend a whole webinar just on this topic, but there's a history dating back to the Nixon administration of sort of battles between Congress and the executive branch over this practice of impoundment. But at least in our view, and I would say mostly the consensus view, the executive branch is not permitted to just say, no, thank you, I don't want to spend this money that Congress has told us to spend. So that was our claim about the future funds, basically saying that the executive branch, the USAID state, has to keep spending the money that Congress was told that it needs to spend on foreign assistance programs. The other side of the case, and this is hence the procedural complexity here, is, and using JRS as an example, when the government said, we're not going to spend any money on existing grants, contracts, or cooperative agreements. We're going to freeze disbursements under those while we review them, and then to potentially terminate them, and then ultimately to terminate them en masse. We argued that wasn't necessarily an impoundment, but that violated these requirements that Congress has applied to all sorts of agency actions. So you mentioned, I have experience under the Administrative Procedure Act. That's a law that basically dictates what agencies can do and when they do things, how they have to explain themselves. And we were able to secure an order from the court saying that the terminations of all of those existing grants and contracts and cooperative agreements was, the phrase is arbitrary and capricious, which is basically the agencies here, USAID and state, didn't explain themselves when they terminated that funding. And so because of those two sort of procedural avenues, the case is unfolded in kind of a herky-jerky way in multiple courts at the same time. So the part about the terminations very quickly went to the US Supreme Court, and we were able to defend our victory that said that the Trump administration cannot terminate these and stop funding these existing agreements during the litigation. Most recently, if folks have seen headlines about a Supreme Court decision in this case, that was about the impoundment side of the case, about future spending. And there, I would describe us as having a mixed result. So the most recent Supreme Court decision allowed the administration to impound about $4 billion of foreign aid funding. But it left in place an order that required it to spend about $6.5 billion of funding, which the government sort of conceded that it needed to spend. So I know that it's hard to capture these complexities in a quick spiel like this, and I'd be happy to answer follow-up questions, but that's the lay of the land. And I think it's most critically sort of keeping in mind that there's two aspects to this decision in this case.
I had a question about the parties to the suit. And there was, obviously a number of big NGOs that have joined this litigation, but there's a number that didn't too. And I wonder if you could speak just a bit to the kinds of considerations that may have been on the minds of agencies that were affected by this executive order and the subsequent instructions that came down, and those that didn't, because I feel like in a lot of cases it may have been that they didn't want to antagonize what they view as a fairly vindictive administration.
Absolutely. And it's a question that I think about a lot, not just in this case, but across a lot of my work involves advising clients that are facing some new adverse action that the administration is taking or contemplating. And there's a real decision point of, do we want to file a lawsuit? Do we want to join a lawsuit? Do we want to speak up publicly against what the administration is doing? And uh, in this case, I think folks were very understandably agitated, and organizations that were affected, I would say, were a bit more willing to jump in as plaintiffs than I've seen in subsequent months with other types of administration actions.
Mm.
I think part of that is because, at least with respect to some of these organizations, one of our plaintiff organizations is called Democracy International, just to use it as an example. They get upward of 90% of their funding from these federal grants and contracts.
Mhm.
For an organization like that, they felt it imperative to get involved, understandably. For organizations that are maybe not quite in that position and have a decision of, you know, they might have multiple things that they have to work with the administration on over the coming years. They might reasonably fear other types of adverse actions that this administration could take against them, which unfortunately is something we see. The calculus is more difficult. And I also think, in very fast moving litigation like this, as I mentioned, we filed a case, I think within about a week of the week or two of the initial executive order. There is such a mad scramble that some of it is just happenstance of like who happens to be attuned to it, given the number of organizations out there. And so that's definitely a consideration, even in this day and age where it's easier to find potentially interested parties and for them to communicate. It's not always the case that everyone who might be interested is sort of synced up right at the beginning.
Do you, I guess, I'm the or the Vice President of Advocacy and Policy for Jesuit Refugee Service. So I try to track some of the litigation. And I look at this just security litigation tool occasionally. And last time I did, there were 404 legal challenges of administration policies of different kinds. And dozens of them involve refugee and immigration policy. And, this, but they run the gamut from suspension of the refugee resettlement program to removal of people to unsafe third countries to expanded use of expedited removal to, access to lawyers in detention to invocation of the Alien Enemies Act. I mean, the list goes on and on, registration requirements, and also like the attack on birthright citizenship by executive fiat. One thing, though, that I'm kind of interested in is that there seems to be a lot of overlap in the legal theories challenging these decisions, and I'm wondering maybe if you could comment on that. I mean, there may be a simple reason for it, but would you speak to that kind of? There's usually an APA cause. There's a separation of powers issue. There's some other kind of constitutional and sometimes a statutory problem as well. Maybe could you just kind of talk to some of the commonalities between the litigations that are going on?
Absolutely. And it raises sort of two interesting and related points. One is more about why we might see that volume of litigation, which is very, very high. But the first about the overlap is a great question. So part of that overlap is explained by the fact that there are certain legal provisions that will apply frequently when the executive branch is taking an action that is novel or goes beyond like typically what is understood as within the limits of an executive branch authority. So you mentioned the separation of powers. Separation of powers sort of stands, it's a constitutional principle that stands for the idea that, Congress makes the laws and the executive branch enforces the laws. And if the executive branch is taking a statute and effectively rewriting it or going beyond its limits, there can be a claim that the executive branch is violating the separation of powers, basically by intruding on Congress's prerogatives. As you mentioned, there are also statutes that restrict what the executive branch can do. The one I mentioned before, and you just mentioned, is the Administrative Procedure Act. And the reason that there are a lot of Administrative Procedure Act claims across all of these cases is that the Administrative Procedure Act is a safeguard on what agencies can do across the board. It's not specific to one agency or the other. It basically says when an agency acts, when it does a new regulation, it has to give notice to the public and the public an opportunity to comment on the regulation. If it goes beyond the Constitution or it violates another statute that Congress has enacted, that will violate the Administrative Procedure Act. If an agency acts arbitrary and capriciously, which I mentioned before was the basis for one of our rulings in the Global Health Council case, that is another basis for invalidating what an agency has done. So you'll see claims under the Administrative Procedure Act essentially anytime an agency, a federal agency, is alleged to have acted unlawfully. And the Constitution, it also applies to agencies, but a reason you see a lot of claims directly under the Constitution is that and this is getting a little bit technical, but might help, especially in talking about cases like the birthright citizenship case. The Administrative Procedure Act does not apply to the president himself. And so if the president takes an action that has legal force, like an executive order that says people are not entitled to birthright citizenship automatically, that can really only be challenged under the Constitution itself, as opposed to the Administrative Procedure Act. And just briefly on the point, and not to get ahead if you had a separate question about this, but you mentioned the volume of litigation. I mean, it's very, very high. Part of that is certainly attributable to the fact that this administration is doing novel things that are promoting a lot of legal challenges. But another reason is that prior to this summer, when the Supreme Court issued a decision in the birthright citizenship case about what are called universal injunctions, it used to be easier when there was a new executive branch action that someone wanted to challenge. A successful lawsuit in that case could shut down that executive action nationwide. And what would happen? So someone would sue in California, and a district court would find the action unlawful, and they would say, the executive branch is blocked from implementing that action anywhere in the country. The Supreme Court in this birthright citizenship case put very significant restrictions on the ability of a court to enjoin, to block executive branch action across the country. And the practical result is that if an organization wants to get an injunction that protects them against what the executive branch is doing, they have a much higher incentive to file their own lawsuit or to have multiple lawsuits pending in different courts at the same time. And so some of the volume is just, you're seeing a lot of different multiple cases challenging the same executive branch action.
And you're seeing the same types of potential legal problems that cross bounds, cross issues, kind of that the administration's committing. I mean, its approach seems similar on different categories of issues, right?
I think that's right. And listen, I served in the prior administration, and we got sued a lot also. There's a certain inevitability to courts are used to resolve policy disputes very frequently in modern times. States, the state of Texas, the state of Louisiana, certain Republican attorney generals would very frequently challenge new actions of the Biden administration. I don't think it's surprising to see lots of challenges to what the executive branch is doing in any administration these days. But the volume of litigation this early in the administration and the sort of grounds on which the administration is defending its positions, I think, is unusual.
Let me ask, I think it's a related question to to go back to the executive order that kicked all of this off, I went back and I read it, and it's worth reading again. The United States foreign aid industry and bureaucracy are not aligned well with American interests, and in many ways are antithetical to American values. They serve to destabilize world peace by promoting ideas in foreign countries that are directly inverse to harmonious and stable relations, internal and among countries. Boy, I gotta say, that's not at all our experience. What they're describing there, and it certainly doesn't describe any JRS programs, but it doesn't describe the super majority of other programs that anybody's familiar with either. I think the JRS PRM funded program in Chad, for example, just to provide an example, it offers protection and education to secondary students and primary schooling in 21 refugee camps. And this schooling is, vital, of course, to the long-term prospects of these students. But they also offer the students all sorts of protections, from child labor to forced marriage to recruitment. Just schooling in general does, to recruitment by armed groups, and protections of all sorts of, from predations of all sorts of different kinds. Other JRS programs themselves provide foster care for unaccompanied children, trauma recovery, prosthetics and surgeries for ISIS survivors, and healthcare for chronically and terminally ill refugees. I mean, that's not, that's antithetical to American values. I guess, as a litigator, how do you address administrative actions based on inaccurate or wildly exaggerated or politically motivated or even fraudulent claims about kind of what's happening with particular programs that are being funded?
Yeah, there are two answers, and they're equally important, I think. One is that it is very significant in litigation to correct the factual record. You want to provide the court with the ample basis to, you want to tell your story. You want to explain why those statements are not correct. You want to, we took pains to provide examples of programs like the ones you just highlighted and how important they are, how there's been bipartisan support for many years for these types of programs, just like the amazing life-saving work. And but the second answer is, I can think those programs are valuable. You can think those programs are valuable. But what really matters in this particular case is that Congress, our elected representatives, thought those programs were valuable. People can have political disagreements about the value of various government programs. And the First Amendment protects our rights. You can write an op-ed, you can take to the streets, you can file your own litigation, whatever you want. But Congress does get to decide what this nation spends money on. And when Congress says we're giving $10 billion to support programs like the ones you just described, a president doesn't, in our view, as stated in our litigation, the president doesn't get to come into office and just say, well, I have a different policy, so we're not going to spend that money at all.
Are you finding that Congress is its level of outrage at kind of not being its power over the purse not being respected is fairly muted at this point? As a litigator, or is it just as an observer?
Yeah. It's individual members of Congress have taken very strong positions about the importance of Congress's power of the purse. The reality is that a majority of Congress has not taken a position on that. And to go back to this litigation in particular, the theory on which the Supreme Court allowed those $4 billion I mentioned to be impounded was that the president had submitted a message, they call it a special message, to Congress proposing that those funds be rescinded. And the administration's position, which the Supreme Court adopted, was that as long as there's one of these messages pending in front of Congress, a court cannot force the executive branch to spend that money. And Congress didn't do anything with that message. It just let it sit. And so I think, just factually, Congress has not been taking a strong stand at this moment on those issues.
Yeah, I mean, do you have a sense of is a litigator kind of what the bottom line position is of the administration on international humanitarian assistance, foreign assistance? I mean, does it think it can refuse to obligate monies for any programs it disfavors? I mean, looking at the litigation, it seems like it's doing its level best, even when you prevail in court to, drag its feet or to challenge things, continue to challenge things in ways that it's not going to, it doesn't seem to be accepting kind of the court's decisions is kind of the final word. And I don't know if there's a concern there or not.
Well, I think there's definitely a concern that's been expressed in other cases, not just this one, about sort of compliance with court orders. I can say, in this particular case, the aspect of the government's position that we found most concerning and we really emphasized, and I would encourage anyone who's interested, the sort of Supreme Court docket has the various public filings in this case, and you can sort of read from the horse's mouth how the government represents its own position. You don't have to trust me, but basically, the position they articulate is that a executive branch has the authority when it has a pool of money that Congress has said you have to spend for a particular purpose. It can wait until very close to when those funds lapse. Funds typically lapse at the end of a fiscal year. Sometimes they're available for multiple years, but typically, there's a point at which they expire forever. And their position is that you can wait until very close to the end and then propose one of these, what I mentioned is a special message. And as long as that period expires without Congress sort of forcing the executive branch to spend the money can lapse permanently. So I do think, they've tried to avoid taking a complete categorical position that they can just totally ignore appropriations, but the logical result, I think, is quite dangerous.
I wonder if you could speak just a bit. And Bridget, I know we're coming to questions soon, so I'll ask one more question and then we'll go to questions. But about kind of what litigation can do and what it can't do as part of an integrated, strategy. Is it a panacea? What can it accomplish? What can't it accomplish? I think that'd be very interesting to hear your thoughts on that.
Yeah, and I think the recent challenges, you mentioned you can view these pages of all these challenges to what the Trump administration has been doing. The administration has succeeded in a very significant majority of these cases by the time they've gone to the U.S. Supreme Court. So I think part of the answer is that litigation can do a lot in theory if you prevail and are able to defend court orders on appeal. They can do a lot to shape the executive branch's behavior. They can do a lot to delineate the boundaries between executive branch power and the legislative branch's power. In this current climate, the executive branch really has a lot of authority, though, because it has been permitted to exercise this authority, and it doesn't have very significant congressional oversight at the moment. And so I absolutely I agree with the premise of the question, which is it's part of a whole. I think litigation has succeeded in restraining certain kind of key actions. It's not going to succeed in every case. It might not succeed in most cases. And so advocacy to the political branches, to the executive branch itself, to the extent that's possible, to Congress, to the public, and public support of litigation, advocacy, highlighting its importance, getting involved potentially, not necessarily as a plaintiff in a case, but also an amicus curiae who files a brief sort of in support of litigation, or just highlighting it, participating in dialogues like this, just to get the word out about things like this. I think it's very important.
Yep, thank you. Bridget, I don't know, do we have questions?
We do. We have several questions. I'm going to start with two that that I'm going to do my best to combine live here because they're probably similar. And they directly relate to something the two of you were just talking about a moment ago. And it is something that I think is on a lot of people's minds. Has there been precedent or is there a mechanism for enforcement of federal court rulings? It seems that even when judges are making rulings, there is no accountability or follow through from the administration to implement. I'm just going to add a bit from the other question is, what's the remedy? How do you hold them accountable? Is it, for example, holding an administration official in contempt?
It's a great question, and it's something we have some experience from in our particular case. So, yeah, the formal answer is that courts do have authority to enforce their own orders. If a court, to take an example, if a court tells an agency that what they've done is unlawful and that they need to stop doing it, and agency officials nevertheless continue to implement the action that's been held unlawful, the plaintiff in the case can go to court and file a motion that says the other side is violating your order, judge, and the judge has a very broad set of authorities to ensure compliance with a court order. That can start with a clarification saying like, no, I really meant it. You need to do this. You need to do it in this particular way. As long as the judge gives like, ample notice, can escalate to monetary sanctions to it can get to a significant level of sanctions. The other, legal enforcement mechanism is appellate courts can, let's say the initial judge who entered the order is not willing to enforce it in some respect. You can appeal those decisions and get a higher court to insist that the order be followed. But I think what I take the questions to be getting at is a very important point too, which is there is a lot of gray area in court orders sometimes, and when the executive branch especially believes that an order is very intrusive into its operations, will understandably have incentives to try to describe their compliance in a way that like makes it sound like they're fully in accord with the court's order. And so there can be a lot of disputes over whether the administration is actually in compliance with an order or not. And at the end of the day, it is up to the judicial system. So if you don't think the judicial system is a good restraint on the executive branch writ large, it is not going to be a very good restraint on the individual parties' compliance with court orders.
Okay, thank you. I'm going to go to Sarah's question next, which is, what international laws and treaties can you use to protect the rights of migrants, refugees, asylum seekers, and immigrants? Where can you file international law claims and have these laws enforced against the administration?
Yeah, will be honest, I have fairly limited experience with international law and treaty enforcement. And I can tell you at a very high level that getting enforcement against United States executive branch officials based on treaty obligations is very difficult unless Congress by statute has implemented the treaty in an enforceable way. So generally speaking, and again, I'm painting in very broad strokes because the sort of international and treaty obligations, and Don, you may well have much more knowledgeable views on this than I do, but generally speaking, international tribunals don't have sort of coercive binding power over United States executive branch officials in the same way that a domestic court, like the courts where my case have been involved in, don't generally have that same authority.
I would just say that I think it's quite clear where you have, like with the 1980 Refugee Act, for example, an explicit attempt to kind of harmonize U.S. law with international law. And so you have kind of a statutory basis, more or less, to make an international law claim. But generally, I think, Sam, like these attempts to, and there's been many over the years, to create a jurisprudence based on international law in the U.S. court systems, it hasn't been hugely successful.
Yeah, I tend to agree with that. I mean, I think there are certain narrow pockets where domestic US law looks to treaties to sort of inform what the legal rules are. But for the most part, you really need to be able to point to some sort of domestic statute that imposes some sort of binding requirement on the executive branch in order to get a court order that actually says the executive branch must do this or cannot do this.
Okay, we will go next to Carol's question. As a former litigator, the fact that these cases have not been summarily dismissed seems to suggest that the administration has viable arguments. What are the administration's strongest arguments here?
Well, the arguments vary quite dramatically depending on the particular executive branch action we're talking about. If the question is specific to the sort of impoundments, stopping of federal funding issues, the argument on which they succeeded at the Supreme Court most recently had to do with this statute that deals with impoundments of federal funds. And their theory is when Congress created this statute about impoundments, it gave the president some authority to propose impoundments to Congress for Congress's consideration. And the theory was while that process is ongoing, where the president tells Congress that he's considering impounding these funds, a court should not be able to step in the midst of that process. And there is some authority, I would say, sort of tangentially related to that area that suggests that courts should not step in when there's a complicated interbranch dialogue going on. Our position in the litigation was that those principles do not prevent a court from telling the executive branch it needs to spend money, especially when the appropriations say very specifically that the executive branch must spend money. So, I'm sympathetic. I represent the plaintiffs in this case, and so agree that the arguments are not particularly strong. But that was the most recently accepted theory. Across the board, government litigators will very frequently raise arguments about things. They sound a bit technical, but sort of, like in the Administrative Procedure Act, one of the requirements if you're bringing a claim under that act is that you show that an agency has done something final and definitive that you can actually challenge, as opposed to just sort of an amorphous statement of policy or something that hasn't fully been implemented yet. And so the administration has won some cases on that theory. It's like what they've done is not, they've stated a policy, but it hasn't sort of come to fruition in a final action.
I think as I read Sam, I don't know what you think about this, but as I read the executive order, you say kind of at first glance, yeah, the administration has the right to review whether these programs are doing what they're supposed to be doing. But then it goes on and it's basically used that order to wipe out, very, very successful programs that are doing exactly what Congress wanted them to do. And some of those programs were expanded during the first Trump administration, so that it doesn't make any really kind of any sense at all. So they've gone beyond any kind of, at this point, legitimate review of programs, operating as they ought to.
Right. And that it highlights something that the government raises in this case and a lot of other cases like it, which is, courts historically have been very deferential to the executive branch when it comes to spending decisions, individual spending decisions, not decisions about whether to spend any money, but rather who gets money. And they've also been very deferential to the executive branch in areas of foreign policy and national security. And at times during this litigation, although it has kind of retreated from this a bit, the government has relied very heavily on this theory that, foreign assistance, humanitarian funding is part of the sort of foreign relations of the United States. It's dealing with foreign nations, and for a court to weigh in and disturb that is sort of an interference with the president's constitutional prerogatives. So you see that in this case, and you see that in a lot of other cases involving immigration and national security issues, tariffs, things like that. You see these references to national security and foreign relations very prominently in the government's filings.
That brought us to the end of our questions.
Great questions.
Just one more, Sam, for you, and that is the law firms in general have taken a lot of hits, for the settlements that they've reached with the administration. And I wanted to ask you and applaud you and Arnold and Porter for taking on this case, because it's like so important. And have you gotten any? Are you at all kind of fearful, the law firm, of retribution as a result of your work on it?
Yeah, law firms are going to have different. It's a difficult time. We talked at the beginning about why do some people get involved in litigation as plaintiffs and why do some people not. It's a very complex array of factors that I'm sympathetic to. We live in unprecedented times. I'm very proud to be at Arnold Porter, where we have been able to take on this type of work, and where we have not, nothing has. No real consequences yet, and we're hopeful that continues to be the case. I think we represent our clients ardently in cases involving the government, where we have to work cooperatively with the government sometimes, and when we have to be against the government. I think it's an important role of a law firm to be able to zealously advocate on behalf of your clients when their interests are being affected, even if that is accompanied by threats of other consequences outside of the legal system per se. So I can't realistically tell you that there's no fear ever. I think everyone has some residual concern about these sorts of things, whether it's from this case or others. But all you can do is put your head down and try to do the best you can for your clients.
And just kind of on behalf of our agency, we just want to thank you and thank Arnold and Porter for taking on this really crucially important case. And also thank you personally for being our first interviewee and our first Ignatian Migration Dialogue webinar. So we'll be looking back on 10 years from now at an anniversary, and we'll lift you up again. Although we want to be in contact in the meantime, if that's okay.
That it would be my pleasure and honor. It's been great to speak with you, and again, really an honor to be the first speaker. And I'm very eager to see others. It seems like you have quite an array on all sorts of really, really important topics. So I'm so glad you're doing this.
Well, hopefully we can invite Arnold and Porter back. I know that you're doing a really interesting analysis that we'd love to learn more about related to the executive orders. So
sure, absolutely.
Yeah. But thank you and best wishes in your work on this particular case.
Thank you so much, and thanks again, and thanks to all the attendees for their interest in this case and in this work more generally.
Okay, thank you, Bridget. I think that's it.
I think so. Thank you, everyone, and please do look out for the invitation to our next webinar, October 28th, with Archbishop Wensky. And also be sure to check your email if you didn't catch all of today's webinar. We will be sharing a link to the full recording. Thank you.
Thanks so much.
Thanks, Sam.
Bye.